Hi, I'm Jason Sullivan of Rathbone Group, and in this video, we're going to discuss the unfortunate situation when your insured files bankruptcy. We have a couple of different videos that go into detail on bankruptcy and the different chapters and how that affects claims and your ability to pursue a tortfeasor. This video is focused on when you have a reimbursement claim against your insured and then your insured files bankruptcy. The most common situation that I think this will arise in is in the circumstance of a med-pay claim. Many states require that the insured pursue an injury claim, and if they receive a recovery, then there's an obligation, either under the policy, the contract, or just an equitable obligation to return the funds that were paid under the MedPay to that insurance provider. The issue that comes up is bankruptcy is federal law, and the analysis is at the time of filing bankruptcy, it puts a stop in time. That is the point in time where everything before that, the court looks at what did the debtor, in this case the insured who filed bankruptcy, have a legal right to. And even though bankruptcy is federal law, they look to state law to determine what rights an insured had, or the debtor, the person who filed bankruptcy, had in any property at the time. Things that are really easy to identify are if they owned a home, if they owned any vehicles, if they had a checking account. On the date that they filed bankruptcy, all of that they owned is included in the estate. With personal injury actions, it can get a little bit more tricky, but it's basically the same analysis. If there is an accident that happened prior to them filing bankruptcy, then that cause of action, the right to pursue the claim, is part of the estate of the debtor. From a bankruptcy perspective, what that means is creditors can't go after the money that's in the estate of the debtor. Rather, the bankruptcy trustee puts it all together, and then they pay out claims according to the bankruptcy code, with secured creditors and certain priority creditors being paid first, and then unsecured creditors being paid at the end. So to highlight how this works, let's take a look at two different states and how they handle the rights and property rights that individuals may have. The first case we'll look at is Tennessee. And in that case, it was In re Calderon. And In re Calderon, so that's how bankruptcy cases are captioned. It's In re, then the last name of the person who filed bankruptcy. But In re Calderon, the individual had sustained an injury, and then they filed bankruptcy. They had received medical treatment, and an insurer had covered some of that treatment. Sometime later, they settled that injury case. Again, injury happened, bankruptcy was filed, settled the injury case after that. The insurer that had paid for medical bills wanted to be repaid. And in that case, the court's analysis was, at the time of the filing, the insured was the sole person who had a claim for the injury. They looked at the fact that under Tennessee law, insurers are not subrogated and they don't have a final subrogation right until there's actually a recovery by the insured or the injured party. So in this case, on the date that the bankruptcy was filed, the insured owned the entire cause of action, and therefore the entire cause of action was included in the bankruptcy estate. So that means that when the case then settled, the injury case then settled later on, after the bankruptcy had been filed, the court held in that case that all of the settlement proceeds belonged to the estate. That doesn't mean that the insurer couldn't recover. They were just going to recover any funds as an unsecured creditor in line at the back of the line with all the other unsecured creditors. So the Tennessee rule is that the insurance company doesn't have a right to recover until the insured has been made whole. And therefore, if there's been no recovery prior to the bankruptcy, that means that the entire cause of action is part of the bankruptcy estate, and the settlement is going to be in the control of the trustee. Let's contrast this with a case in Ohio. In this case, I'm looking at French v. Frey, and it's F-R-E-Y. Dangerously close to French fry, but it's not. French v. Frey. In that case, the court looked at Ohio law and said, okay, what are the rights that the injured party had? Again, we have a case where there was an injury, bankruptcy was filed, and then a subsequent settlement. In this case, the court looked at Ohio law and said, once the insurer had made payment, they had an independent right towards the recovery of the proceeds. They didn't have to wait for the insured to be made whole to have a right of subrogation. Their right existed on the date of payment. Therefore, in that case, the court looked at it and said, well, it's not fair that The insured has an injury claim, yes, but the insurer has their own independent claim. And we can't pull that into the bankruptcy estate and let the trustee distribute that fund to all the other creditors. Rather, the insurer had an absolute right to the first, in this case, $3,000 that they had paid, and it didn't matter that the recovery had come after a bankruptcy was filed. So you can see there, it matters a lot on how the state law determines the rights of individuals, and then that way you know exactly what's included in the bankruptcy estate. Another case to consider is, what happens if your claim and the accident happened after the bankruptcy is filed? So we've looked at cases where there was an incident, bankruptcy was filed, and then a settlement, how that's treated in different jurisdictions. In a case where there's a bankruptcy filed, then there's a subsequent accident, and then your company makes, let's say, MedPay payments on that claim, what is your right to recover those, knowing that your insured has filed bankruptcy? And in these cases, again, we'll look at the federal bankruptcy law, and the estate is created based out of the rights and property rights that the debtor, the person filing bankruptcy, had at the time they filed. If a loss hasn't even happened yet, then they don't have any right to recover or a cause of action against the person who caused the loss. So that cause of action is not included in the bankruptcy estate. So your right to recover your MedPay claim should still exist, because that pool of funds, if ever recovered against the at-fault party, that's going to be used to pay your claim or a part of your claim, that pool of funds is not in the bankruptcy estate, and therefore it's not protected. That doesn't mean, though, that you don't have to take any action in the bankruptcy case. You may need to file an adversarial action in order to say, yes, that money and our claim and any reimbursement that comes in the future is not part of the bankruptcy estate. It's just going to depend on how the insured attorney and the trustee treat your notification of the lien. So, to recap this issue, if your insured were to file a bankruptcy and you are trying to seek reimbursement of a MedPay claim, first you want to look at, did the loss happen before the bankruptcy was filed or after the bankruptcy was filed? And if it happened before the bankruptcy was filed, then you're really going to need to look at the state law that says what the rights of the injured party are. Do they control the entire cause of action and there's no reimbursement or subrogation right until after they've been made whole? Or is this a state that's going to say, no, the insurer has an independent action and that money that they're owed isn't going to be sucked into the bankruptcy estate? If you have any questions on bankruptcy law or how to pursue a subrogation case in that situation, please feel free to contact us. Also, if you have any video ideas or questions, just things you're dying to know how this works in the subrogation world, let us know at info@rathbonegroup.com. We'd be happy to reach out to you. For Rathbone Group and on subrogation, I'm Jason Sullivan, and that's the long and short of it.